The first documents appeared quietly, without ceremony, without context, and without explanation. They did not arrive as a single file or an organized archive. They surfaced in fragments, in court filings, in sealed exhibits slowly unfastened, in transcripts once marked confidential. At first glance, they looked ordinary. Names, dates, flight logs, phone numbers, settlement language written in careful, legal tones. But according to records, what made these documents different was not what they said plainly, but what they suggested when placed side by side. Reports suggest that for years, these papers existed in plain sight, protected not by locks, but by indifference, by complexity, and by the assumption that no one would ever read them closely enough to connect the patterns. The documents did not accuse. They did not explain. They simply recorded. And yet, once released, they began to raise questions that stretched far beyond one man, one investigation, or one courtroom. According to court records, the name Jeffrey Epstein appeared repeatedly in civil complaints long before the public understood who he was. In the early filings, he was described in restrained language: a financier, a private individual, a man with unusual wealth and unusually powerful connections. The documents did not explain the source of that wealth. They did not list clients. They did not clarify how influence was obtained or sustained. They simply acknowledged its existence. What the documents did make clear was access. According to flight manifests submitted as evidence, Epstein traveled extensively, often aboard private aircraft. The logs recorded destinations, dates, tail numbers, and passenger initials. They did not explain relationships. They did not record conversations. But the frequency of certain names appearing alongside his raised questions that would linger for years. Documents indicate that these records were known to investigators long before the public ever heard of them. In depositions taken under seal, attorneys referenced travel schedules, calendars, and address books. Some pages were heavily redacted. Others were sealed entirely. According to procedural filings, motions to unseal were repeatedly delayed, sometimes without explanation. Reports suggest that this delay was not accidental. In legal systems, delay often functions as a form of protection. Cases lose momentum. Witnesses grow older. Public attention shifts, and documents, even explosive ones, remain inert so long as they remain unread. According to records, the first civil suits involving Epstein settled quietly. Non-disclosure agreements were signed. Financial compensation was issued. Language within those settlements emphasized resolution without admission. The documents closed cases but left questions open. In later filings, names appeared not as defendants but as references. Individuals described as associates, contacts, guests. The documents were careful. They did not allege criminal conduct where none had been adjudicated. They simply recorded testimony, statements, and recollections, often conflicting, sometimes incomplete. According to deposition transcripts, witnesses described properties in multiple locations: residences in New York, Florida, New Mexico, and a private island in the Caribbean. Documents indicate that these locations were central to many accounts. The properties themselves became recurring fixtures in the paperwork, mentioned again and again, as if geography itself were part of the story. Reports suggest that law enforcement agencies across jurisdictions were aware of Epstein for years. Internal memos referenced investigations opened, closed, and reopened. According to records, some inquiries stalled after limited cooperation. Others were redirected. Few progressed to public prosecution. One document, cited repeatedly in later litigation, outlined a plea agreement reached in Florida. According to court records, the agreement was unusually broad. It included not only Epstein, but unnamed potential co-conspirators. The language effectively granted immunity to individuals whose identities were never publicly disclosed at the time. Documents indicate that this agreement was negotiated behind closed doors. Victims, according to Filings, were not fully informed of its scope. The paperwork shows notifications sent after the fact, not before. Years later, judges would question the process, but by then, the agreement had already done its work. Reports suggest that this moment marked a turning point. After the agreement, civil litigation slowed. Media attention faded. Epstein resumed public life with minimal visible restriction. According to financial records, his wealth remained intact. According to social records, his access did not diminish. The documents from this period are notable for what they omit. There are few explanations, few justifications. The absence itself became a kind of evidence, though not the kind that fits neatly into a courtroom. According to later filings, journalists attempting to access sealed materials encountered resistance. Motions were opposed. Arguments cited privacy, irrelevance, and potential harm. Judges often agreed. The documents remained closed. Then, years later, circumstances changed. According to records, new lawsuits were filed by individuals who had previously been silent. Some cited fear. Others cited sealed agreements they believed were no longer enforceable. The filings included renewed requests to unseal prior documents. This time, courts were more receptive. Reports suggest that the shift reflected a broader change in public tolerance for secrecy. What once seemed acceptable now appeared suspicious. The same documents, viewed through a different cultural lens, carried new weight. As materials were released incrementally, patterns began to form. According to document analysis, certain names appeared repeatedly across unrelated filings. These names were not accused. They were mentioned, referenced. Sometimes only as initials, sometimes as full names, depending on the document. The effect was cumulative. Each release added context. Each context added tension. Flight logs showed routes to private islands. Calendars showed meetings scheduled around those trips. Address books listed contact information that overlapped with guest lists. None of these elements alone proved wrongdoing, but together they raised questions that could not easily be dismissed. According to sworn testimony, some witnesses described being instructed not to ask questions. Others recalled being told that certain individuals were untouchable. These statements were not corroborated in every case. Some were challenged. Others were supported by circumstantial documentation. Documents indicate that powerful institutions were aware of allegations long before public exposure. Universities, financial firms, and foundations appeared in the paperwork, sometimes as employers, sometimes as beneficiaries of donations. The documents did not accuse these institutions of crimes, but they did record awareness. Reports suggest that money played a central role. Financial transfers documented in bank records showed complex flows between entities, shell companies, trusts, nonprofits. The structure obscured origins and destinations. According to forensic accountants cited in filings, the complexity itself raised concerns. The documents also revealed something else: silence. According to correspondence entered into evidence, some individuals declined to testify. Others invoked legal protections. Some statements ended abruptly, cut short by objections. Pages were redacted. Names were blacked out. Each redaction functioned as a reminder of limits. Even as documents surfaced, boundaries remained. According to records, Epstein's arrest years later reopened scrutiny of earlier decisions. Prosecutors referenced prior files. Journalists revisited old settlements. The same documents, once dormant, now became central. Then came Epstein's death. According to official findings, the death was ruled a suicide. The documents surrounding the event included incident reports, surveillance gaps, staffing logs, and procedural reviews. These records did not allege foul play, but they documented failures. Reports suggest that the timing intensified scrutiny of the documents. With the central figure gone, papers assumed greater importance. There would be no testimony from Epstein himself. Only records remained. In the aftermath, courts faced renewed pressure to release sealed materials. Victims' attorneys argued that transparency was essential. Opposing counsel argued privacy and due process. Judges weighed competing interests. According to subsequent rulings, some documents were unsealed. Others remained protected. Each release sparked headlines. Names circulated widely. Context was often lost in the noise. The documents themselves remained restrained. They did not editorialize. They did not speculate. They recorded statements under oath, financial data, travel schedules, and correspondence. What shook the world was not a single revelation, but accumulation. Reports suggest that the cumulative effect undermined public confidence in systems designed to protect the vulnerable. The documents implied that influence could slow investigations, that wealth could reshape outcomes, that silence could be purchased. Yet the documents also showed resistance. Attorneys who persisted, journalists who filed repeated motions, survivors who returned to court years later despite exhaustion and fear. According to later filings, some individuals named in documents denied all allegations. Others issued statements emphasizing that inclusion in records did not imply wrongdoing. The documents themselves often supported this distinction. Mentions were not accusations. Still, the questions remained. Why were certain investigations limited in scope? Why were agreements so broad? Why were documents sealed for so long? According to legal scholars cited in Filings, the Epstein documents exposed structural vulnerabilities, prosecutorial discretion, settlement practices, the use of non-disclosure agreements in cases involving public interest. The documents did not resolve these issues. They illuminated them. As more records were reviewed, attention turned to what might still be missing. According to indexing logs, some materials were referenced but never produced. Others were destroyed according to retention policies. The absence itself became part of the story. Reports suggest that even now, not all documents have been released. Courts continue to weigh motions. Redactions remain. Names remain concealed. The story, as recorded in these papers, is unfinished. According to records, the documents that shook the world did not do so because they revealed a single hidden truth. They did so because they revealed a system in which truths could be delayed, diluted, and deferred. They showed how power intersects with process, how silence can be procedural, how accountability can be negotiated. And they left behind questions that no document alone can answer. Questions about how many decisions were influenced by fear or favor. Questions about who benefited from delay. Questions about what justice looks like when the paper trail outlives the people involved. The documents remain. Filed, indexed, partially sealed, waiting. According to records, they will continue to be read, reinterpreted, and contested for years to come. Not because they offer closure, but because they refuse to. In the end, what shook the world was not simply what the documents contained, but what they revealed about the spaces between the lines. The silences, the omissions, the careful language that recorded everything except motive. And in those spaces, the story continues to echo.